The verdict came down today for Prince Harry's court case against the Daily Mail, and he has been officially deemed a loser.
So Harry dragged the publisher of the Daily Mail into the High Court, alleging phone tapping, home break-ins, and private information raped out of banks and phone companies by deception. And today, a judge threw the whole thing out. Every single claim dismissed.
Breaking news, Prince Harry just lost all of his claims in court.
Harry called it a whitewash, and the judge called it unproven. And that is only the opening, because there is a legal bill that could touch £50 million. Buckingham Palace bedroom he lost by answering too late, and a brother 11 miles away who spent the very same afternoon just doing the job.
The media is just making things up. The media is against him. Well, a judge has looked at the quote-unquote evidence and really found that there was none. Yes, there were feelings. Yes, there were heartbreaks. And yes, some of that was understandable, but it did not rise to the preponderance of evidence. So there is so much to go through here with this court decision, the reaction to it, and how the judge looked at the evidence and simply found that of the balance of probabilities, it was kind of likely that the journalists actually got their information legally, and Prince Harry and his other co-claimants are simply grasping at straws.
But today, you know what? We're going to do something a little bit different, do a little bit more of a deep dive in this case. And so the verdict came down a little after 2 today.
Prince Harry had actually just arrived at Chatham House to speak with veterans, do an event for Invictus, and he walked in right before the verdict was announced and was told in there somewhere that, guess what? You lost it all, Harry. You lost it all. You did not win on a single count.
Didn't come out right on time. There was a little bit of a delay. This is the biggest of Prince Harry's cases against the media. He has the most animus towards the Daily Mail. And in the other cases that he brought against Mirror and Rupert Murdoch's group, both of them ended up settling. The Mirror settled for a small amount. Rupert Murdoch's group, which includes the Sun, settled for about $10 million, and the Mirror settled for about 100-some-odd thousand.
And so Harry got very different settlements, but this was the biggest of the big. And there were 6 other co-claimants with Harry. So there were 7 altogether. This included Elton John, Elizabeth Hurley, and Baroness Lawrence. And so they brought this massive case. And the idea was that if we can prove, because many years ago, you might remember, that the News of the World, particularly a UK publication, was determined to have been phone hacking. So what that meant is, sort of in the early days of cell phone, if you figured out somebody's voicemail code, you could actually get into their phone.
There have been other allegations of illegal information gathering by journalists. Of course, that is wrong. Nobody's claiming that is not wrong. So in the Leveson inquiry, they went over all these details, and the Daily Mail was mostly able to skirt this.
And so the idea was really pushed by Hacked Off, which we'll get back to later, is that if they can push this narrative and push this case forwards, which was this was a weak case. And if they can push this case forward and get the judge to side with them, then they can bring a second inquiry.
While there were bad instances of information gathering, there were obviously some unethical things done within journalism in order to obtain information. This is especially true in the late 90s and early 2000s.
This is not really happening now. And really, this sort of boils down to almost a witch hunt to punish journalists. The people who were the fixtures of their articles thought went too far. Now, sometimes, yeah, they might have gone too far. But what really this case boils down to is emotion over facts. There were a lot of emotions here, but very little facts.
One of the most interesting phrases that appears on 61 pages of this decision, it's over 400 pages, is balance of probabilities. If you dig into the details of this case, and we'll go over one particular instance regarding Harry, this means looking at all the information together. Could this information have only been gathered through illicit or illegal means, or were there legitimate alternatives that had equal value?
I think the judge basically determined at the end of the day when it came to this case is that both sides could have merit. The claimant side and the defendant side. The defendant said, we gathered this information lawfully. We had friends with connections, which I think the judge was like, yeah, that's probably broadly true. And I think it is true. And it's also possible that some of it was gathered through illicit means. But oftentimes, for many of these cases, the statute of limitations had either passed. That's actually what the judge determined for Sadie Frost, is that the statute had passed completely. And so her claims were illegitimate from the jump.
People also couldn't remember quite as much. So how can a decision be made about whether something was legal or illegal if it's based only on background information? The burden was on the claimants. They had to prove that the information could have only been gathered.
And the judge basically said in all cases that there's no way to determine that. There is no way to say without a shadow of a doubt that only if you're using illegal information could you acquire information A. He's like, they could have gathered it through A, B, C, D, E, F. We don't know. And if you're going to prove it, you have to prove without a shadow of a doubt A. But what we have in these particular situations with a lot of this is that friends knew. And yes, Harry claims that none of his friends would ever leak.
Only through illegal information gathering. But that couldn't be proven. The journalists, particularly Katie Nicholl and Charlotte Griffiths, were friends with people in Harry's circle and could have obtained this information completely legally. Let's go ahead and get into one particular case because it's important to actually look at the information. We're going to do this video a little bit differently.
So, I'm going to go over this. We'll show pictures and stuff, but I think it's actually, I like having a physical copy so I can look at and highlight. So, this particular, although this is actually a different thing just about Harry, but we'll begin here with one actual case here, which is the article entitled Harry's Older Woman. This was Mail on Sunday piece from Sunday, December 8th, 2002. And it was written by Katie Nicholl. So this is in regard to Natalie Pinkenton, who was apparently sort of in a pseudo relationship or very heavily flirting with Prince Harry.
Prince Harry alleges that the information was attained by unlawful information gathering. The UIG pleaded case was that Ms. Nicholl obtained Ms. Pinkerton and Tim's phone number and then commissioned a blagger. A blagger is someone who obtains illegal information, in this case to obtain itemized billing data. According to Harry's claim, that was the only way she could have known that he was pursuing Natalie. The issue, therefore, is whether Prince Harry proved, on the balance of probabilities, that the relevant information was obtained by unlawful means carried out or commissioned on Associated's behalf.
So it says Prince Harry's evidence was not only a very small group of people knew that he and Ms. Pinkenton were in close contact, while he accepted that that may have been a regular contact with her, nobody could have known the detail, save through access to his call data. So that's his evidence. Which, I mean, just think about that. I'm trying to think of something. This is just so dumb. I can't even think of a good example in real life. But it's like, you told, let's say, a small group of people you were pregnant. It's entirely possible that despite telling this small group of people, let's say there's 6 people, there's a 1 in 6 chance that one of them blabbed to somebody. And maybe they didn't mean to, maybe it was by accident, maybe they weren't thinking, maybe they thought this person knew, something like that. It's entirely possible that even though you told somebody not to say anything, people still say something.
The entire case can't be based on the assumption that nobody is going to say anything. That's not how this works. The judgment goes on to say that Ms. Nicholl addressed this in her first and second witness statements and said she did not remember it. This dates back to 2002. That's well over 20 years ago. Journalists work so quickly that sometimes even last week's work is hard to remember.
In terms of videos. And people tell me, oh, you did something. I was like, really? I guess I probably did, but I don't remember. I move so fast too, because that's part of the thing that maybe if you're not in the journalism news industry, that you forget.
Unless it's a major story, things move on quickly. This was a relatively minor story from a long time ago. It's not surprising she doesn't remember it clearly. She said she reviewed a page of her notebook and a recording of the conversation. So that's interesting. And it was well known that they were friends with a flirtatious relationship. She added Ms. Pinkenton never volunteered stories about Harry. They were on good terms, and Ms. Pinkenton would sometimes speak to her off the record and had several sources that knew both parties at the time. Katie Nicholl explained that she was friends with these people, and they would speak to her off the record and share information. That's perfectly legitimate. So, addressing directly the allegation about Ms. Pinkenton's phone number, sorry, I keep pronouncing her name different ways, my apologies, and the itemized billing data, she said that the number written in her notebook was Ms. Pinkenton's number. She thought she would have been given it either by Ms. Pinkenton herself or by one of their many mutual friends.
She said it would not be unusual for her to have this information because she spoke to Ms. Pinkerton, so Natalie, several times for the Mail on Sunday.
She also denied the allegation that information suggesting Harry sent Ms. Pinkerton text messages all the time and constantly talked about her had been obtained unlawfully. She explained that this most likely came from one of her close contacts within Prince Harry's circle, including the source described in her first witness statement.
So it says here at 474, Prince Harry also relies on hearsay evidence from Ms. Pinkerton. Notice in which she had never once sold a story, been in any way indiscreet, or ever disloyal, and had previously gone on the record to deny claims to the contrary. So this is key. So she never once sold a story, but that doesn't mean she didn't talk to the press and share stories. She just didn't get paid for it. Like, that's the nuance there. And talking about indiscreet or ever disloyal, it depends on what she means by that. That could mean anything. That doesn't mean that she didn't talk to Katie. She probably thought she was talking in confidence and thought Katie was loyal and would share her perspective. Like, that's not difficult. So Harry submits that the information in the article was private and could not have been legitimately known outside a very small circle.
Again, Katie Nicholl was connected to Harry's circle in one way or another. Harry relied on references to his bombarding Miss Pinkerton with text messages and emails, along with his own evidence that nobody would have known that level of contact except through access to call data. He argued that Ms. Nicholl's explanation for obtaining Miss Pinkerton's phone number was not credible, that not all of the reported information appeared in her notebook, and that the proper inference was that the information came from unlawful information gathering. Again, unlawful information gathering, most likely voicemail interception.
But again, in terms of this very key phrase here, the burden is on Harry to prove on the balance of probabilities that the relevant information in the article was obtained by unlawful means. So the contemporaneous material demonstrates that Ms. Nicholl did have direct contact with Ms. Pinkerton, in which she checked whether Prince Harry had attended the party at Ms. Pinkerton's home, and that Ms. Pinkerton confirmed that he had. Ms. Nicholl's evidence was also that she had several times in Prince Harry's social circle.
However, there were people close to Harry, including someone who was sometimes present during his phone calls and who had, on at least one occasion, been shown some of his text messages. The court accepted that evidence regarding the sourcing of the story. The claim also alleged that Ms. Nicholl herself had engaged in voicemail interception. More critically, this became another problem with the claimant's case. One allegation claimed that Ms. Nicholl committed unlawful information gathering, but a different allegation was introduced during the trial.
And saying that she had engaged in voicemail interception. And the judge was like, that was not what was pleaded. That was not in the scope of this case. So you need to stop doing that, because you can't bring her in as a witness claiming one thing and bombard her with a different accusation. You have one accusation that has been here. And so the claimants would shift the narrative, which again doesn't look good to a judge. So I guess Ms. Pinkerton responded to all of this, and the judge determined that it does not materially assist the claimants. It is untested hearsay and in substance goes only to Ms. Pinkerton's denial that she sold a story or had been indiscreet. It does not demonstrate the information in the article was obtained unlawfully, nor does it contradict Ms. Nicholl's evidence that she had sources other than Ms. Pinkerton herself within the relevant social circles. So standing back, this is 485.
Prince Harry failed to prove unlawful information gathering in relation to this matter under any of the arguments presented. The claimants failed to prove that Ms. Nicholl obtained Ms. Pinkerton's phone number and commissioned a blagger to obtain itemized billing data. They also could not rescue the claim by shifting during the trial to a new allegation that Ms. Nicholl herself engaged in voicemail interception.
So that is one instance there, and I think that makes sense. We do also have here like a little appendix looking at the witnesses. It talks about Prince Harry, talks about how he was a careful, candid, and consistent witness, coherent and credible in his account of his position during his time in the royal family, and his lack of knowledge of UIG and the extent to which attribution in articles to friends or sources misled him. So again, Harry has his own ideas, and that's fine. That's what the judge is saying. He has his own beliefs and understanding of what happened to him, but that doesn't, again, fully encompass everything.
In any event, the court accepted Ms. Nicholl's evidence regarding the lawful sourcing of the information. The judgment emphasizes Harry's experience as a public figure familiar with media scrutiny and legal action, concluding that parts of his account rely on hindsight and overstate the privacy or exclusivity of the information at issue.